So welcome back, everyone. I want to say hi to everybody that's watching us and liking us and everything on Facebook. Hi. You got to follow us. We're going to be sharing the show later on after the show tonight, and you guys can share it, and again, just keeps going and going and going. My next guest, he's been on my show once before. I have with me Matt Koglmeier, and he is the owner of Koglmeier Law Group. We were talking that you're a personal injury attorney, but just before you came on, there happened to have been an ad out that interests you. Welcome to the show. Tell everybody a little bit about yourself and what you do and what we're going to talk about today.
Well, thanks, Carol. It's nice to be here again. I'm an attorney. I've been practicing in Mesa for about 36 years now. I do personal injury cases. I've been practicing in that area since I started practicing law, and I think it's a fascinating area. We're able to help people who have been injured by the negligence of others and sometimes the intentional acts of others. And we have our firm is small, but we give people the personal attention that they need and deserve.
Well, here's the other thing I want to get out there. A lot of people out there somehow think that when you're a personal injury attorney, that, that people out there are sue happy, right? But you know what? People deserve, this is their right to get compensated for something that might have happened to them, correct?
Certainly. People are entitled to be compensated for pain and suffering, lost wages, medical bills that are caused by the negligence of others. That's been the law since thousands of years, basically. We go back to biblical times when you hear about the eye for an eye and a tooth for a tooth. They didn't do that literally. They would say you can compensate people for their loss, or we're going to take your eye or your tooth, which is kind of a bizarre way to look at it in our society. But that's where it dates back to. So it's nothing unusual. People are entitled to that, and they should be compensated for the injuries that are caused by the negligence or intentional acts of others.
Now, today when you said, just before we came on, there happened to be this add-on that you said, oh my God. Now let's talk about it, because you said to me, I want to talk about dram shop cases, and I was like, what is that? Go ahead.
Well, a dram shop case is something that is a cause of action in Arizona where bars, servers of alcohol, are responsible to make sure that they don't overserve patrons. Certainly when people come in, if a bar serves someone to the point of being intoxicated, obviously intoxicated, then the law says they're responsible if that person goes out and causes an accident and injures another person. So some people think that only the drunk driver is liable for the damages, but it could very well be the bar owner and the people who serve the alcohol to an excess. They have a responsibility. They have a license under Arizona state law, and that license requires them to serve responsibly. We see commercials all the time that says, drink responsibly. It is a plague in our society for drivers getting drunk and going out and injuring people. And we know that as people drink more alcohol, their inhibitions are lessened. They want to drink more alcohol, and they drink to excess. So a bar has a responsibility to make sure that they do not overserve a patron. So if that happens, then they know that patron's typically going to go out, get behind the wheel of a vehicle, and they cause terrible damage, not only to themselves, but also to others, and they victimize people. It's a sad thing. And the commercial we saw was the Mothers Against Drunk Drivers, the one we were listening to. And it's unfortunate for anyone who's been the victim of a drunk driver. And certainly it's the drunk driver's fault. There's responsibility there. But as I said, bars have responsibility also.
Well, I think it's a great time that you're on, because not only are bars, but I'm just going to say this, there are people that are having big parties right now, okay? And, you're serving. And if somebody left your house and got into an accident or did something, couldn't that fall back possibly on that person too?
Well, typically the dram shop laws apply only to bars and people who are licensed to sell alcohol. Certainly we have a social responsibility to make sure that we don't overserve our friends and then allow them to get in vehicles. Friends don't let friends drive drunk, right?
They do.
And that's the way it should be. Mm-hmm. And certainly if someone serves someone to excess, there's certainly arguments that you could make that a social host may be responsible for that. But typically the dram shop laws statutorily are aimed at the bar owners who have a responsibility because they've obtained a license by the state.
Before you came on, you also said this is rampant in our state right now.
It is. Yeah, it's running rampant. I mean, we know that people go into bars. We know people are overserved. We know that even though bars require their bartenders and their servers to have Title IV training under Arizona law, that they don't always follow the alcohol policies. They don't follow those things which make common sense. Certainly, bars have a motive to sell alcohol. They want to make money. They're in a business, and there's nothing wrong with making money. But if you're going to do that, then you have to do it responsibly, and you have to make sure that when you serve your patrons that they're not overserved to the point where they're obviously intoxicated, or to the point where you knew or should have known that they would become intoxicated. And if that does happen, and you see people get drunk in bars all the time, you see it, I see it, it can be restaurants, it can be, any type of a bar, they have a responsibility then to attempt to get that person into a cab or to an Uber or a Lyft and get them so they're not in control of a vehicle, because a vehicle is a dangerous weapon in the hands of a drunk driver.
Now, can you help anyone from anywhere? Or do you work, in the Valley? Do you work Valley-wide?
We work Valley-wide. We work statewide.
Okay, statewide. And when we were talking, you said that you are on a contingency basis, and I think people, want to understand what that really means.
The contingency fee means that our fee is a percentage of what we collect. If we don't collect anything for an individual, there is no fee. They don't have any responsibility to pay us a dime. People know it's common sense. Lawyers can be very expensive. And we handle these on a contingent fee basis because we know that people need access to lawyers. They can't do it if they have to pay an hourly rate on a personal injury case. Personal injury cases can be very time consuming. You could put in literally thousands of hours on a case. And if a person had to pay on an hourly basis, most people couldn't afford it. They would not have access to the courts. They wouldn't have access to those remedies that they're entitled to under the law. So we handle these on a contingent fee basis, which means simply we don't get paid unless we collect for you.
Okay, now you are, when they call you, you said that you do free consultations, obviously.
Absolutely. Yeah, we get in touch with the person. We'll do free consultations. They can do it at our office. If they're in an accident, they don't have transportation, or they're injured and they can't get to our office, we'll go to them. And it doesn't matter if it's in Phoenix, it doesn't matter if it's in Kingman, it doesn't matter if it's in Flagstaff, Tucson, Sierra Vista, Bisbee, wherever it is in the state, we'll travel to them.
Now, their phone number, it's 480-962-5353, and the website, and I'm going to spell it out for everybody, so it's Koglmeier Law, which is Koglmeier law.com. Go ahead, tell me what you want.
I'll spell it correctly.
Is that wrong? Okay, I'm sorry.
It's all right.
It's not easy.
Hey, you're not the first one to misspell my name.
Okay,
so
go ahead. Just tell them what it is. So go ahead, because you know how to do it.
It's Koglmeierlaw.com. KOGLMEIERLAW.com. It's the common spelling.
Now, you want to go ahead and give them a call, and they'll do a free consultation. And you know what? It is Friday right now, and it's Friday night. Somebody might get into an accident, and it might have been just in this type of a case. You won't know until you call and find out, because it's all about talking to you about what happened and finding out whether they have a case.
Absolutely. You have to find out the facts of each case, and you have to find out who is responsible. And a lot of those things require investigation. It requires you to talk to the client. And when they come to our office, they're always going to meet with an attorney. They're not going to meet with a document preparer. They're not going to meet with a clerk or a paralegal. They will meet with an attorney, so an analysis can be made of their case, and we can tell them what their rights are. We can tell them what their statute of limitations may be, because they're different under different circumstances. And you really need that legal analysis to be able to have the knowledge to know what your remedies are.
Phone number is 480-962-5353. It's Koglmeier, which is Koglmeier law.com. Hang tight. We're going to be back in just a minute. Welcome back. So we are talking right now with Matt Koglmeier, and he is the owner of Koglmeier Law Group. And we've been talking at the break because there's so many different things that personal injury covers. It's not just, car accidents, or we were talking that was pretty interesting to be talking about these dram shop cases, which is amazing really, what happens. And some people get terribly hurt by these drunk drivers, and there are laws out there to protect people. But today, right now, we were talking about dog bites.
Absolutely. Dog bites are another plague. I mean, people don't control their animals, and they're obligated by law to control their animals. People are getting bit by dogs all the time, and they can be very serious. Even small bites turn into terrible things. They get infected. They can have medical bills that are horrendous, and they can have a significant effect on someone's life, particularly when they want to deal with dogs in the future. I know people that have been bit, and they're afraid of dogs for the rest of their life, and it's kind of a sad thing.
Sure. Now, what did you say that they don't know about dog bites? You said you wanted to go on this a little bit longer, so let's go for it.
Sure. Dog bites are kind of an interesting thing, because when people are out walking their dog, or their dog gets loose off the leash or escapes from the backyard and winds up biting someone, people think, well, my goodness, I'm sure they don't have dog insurance. But the reality is that if they have homeowners insurance, that is an avenue for recovery of damages for what that dog does. And so there is typically an avenue for recovery. Even people who have renters insurance, and a lot of people have that today. There's a lot of landlords out there that require people to have renters insurance. So there are places to recover those damages where people are covered, just like automobile insurance. People buy insurance to protect from the losses that they don't want to incur themselves. And that's what homeowners insurance is for, and you can use that in order to collect your damages against a person who has allowed their dog to get out and to bite you. There's some limited defenses in dog bites. So under our law, there's two causes of action, basically. One is common law. And under common law, a person needs to know the propensity of their dog, that the dog has a propensity to bite. So that's basically the old rule where it said the first bite was free. Well, there's a statute now in the state of Arizona which says the first bite is not free. The person is responsible for what their dog does. It's strict liability. There's only one defense, and the defense is that the person who was bit provoked the animal. And that can take a form in a number of ways. If a person's poking at a dog and bugging the dog and irritating it, and the dog turns back, snaps and bites, that's provocation. But if you're walking your dog down the street and you see another dog running at it, and you grab your dog to try to protect it, which is a natural instinct of a dog owner. You love your dog. You want to protect that dog. And you pick up the dog, and then the attacking dog bites you instead of your dog. There's no provocation there, and there's liability for the dog owner whose dog bit you.
I know somebody that had that exact same thing happen, and I'm sure a lot of people can relate, especially people that live in apartments, the apartment buildings, because they're out walking their dogs, and this dog, she lost control, or he lost control of the dog, and the dog ran up and was trying to get her dog. So, of course, just like you said, she grabbed the dog, and the dog bit her, and she was very severely hurt, actually.
It happens all the time. In fact, recently I talked to a woman who was bit by a dog, and in fact, not one dog, but two. There was a woman about 110 pounds walking two dogs, which each weighed over 100 pounds. And when they saw the victim woman walking her dog, those dogs just took off towards her to get her she had a little dog. And those two dogs took control of the person who was walking them and literally drugged that person right down, and they attacked the dog. And there was no way that the person walking those dogs could control. A 110-pound woman simply cannot control, in most cases, two dogs that weigh over 100 pounds each, if those dogs want to get away. And that's exactly what happened.
Right. And it can happen to anyone, anywhere. And that's why you got to write this information down. That's what I like about my show. It's informational. And so anything can happen at any time, whether or not you're hit by a car or you get hit by a dog that's going to bite you, maybe even two. You might want to write this number down. The phone number is 480-962-5353, and your information is on your website, all about you and how long you've been doing this and that and the other thing, which is Koglmeier Law. It's KOGLMEIR law.com. I got it right. Where did I get wrong?
You left out an E.
Where did I put that? I'm doing yours right here.
Koglmeier.
Okay, so it's Koglmeier
There you
law.com. I'll get it right the next time he comes on. Okay, so anyway, you do free consultations, and when you work with somebody, it's on a contingency basis. We want people to understand that. And the other thing that you wanted to talk a little bit about today was, accidents that happen at work.
Accidents happen at work all the time, and people want to know, what are my rights against my employer? What are my rights against anyone else? Typically, if you're an employee, you're covered under workman's compensation laws. And when you begin your employment, if you don't want workman's compensation to cover you for injuries on the job, you have to make an election. And so if you fail to make that election, then you're going to be covered under workman's comp law, which simply means if your employer is negligent and you're injured on the job, you do not have the right to sue your employer. Your sole remedy is to collect workman's compensation benefits. Those are severely limited. I mean, workman's compensation benefits, for anyone who's ever received them, they're limited on the amount of wages that you'll collect. They do cover your medical expenses, but they're not going to typically give you money for pain and suffering except on basically a scale that's set by statute in the state of Arizona. But the main thing is you don't have a right to sue your employer in most cases. Now, if your employer is grossly negligent, then you can make an election immediately after you're injured, but most people don't understand that. In order to make that election, you have to waive and refuse any workman's compensation benefits, which include medical bills or any lost wages. And most people don't really find that out until much later. So in the event your employer goes so far beyond normal negligence, which is called gross negligence, then you can make that election and you could sue your employer. So there's an avenue to do that. But as I said, most people don't understand that. They don't know it. They've never been told. And they don't know what that right is. And besides that, they've been hurt. They're wanting to get their medical bills taken care of, and those are taken care of in a way that's somewhat it's done without them even knowing it, because the bills are submitted to Workman's Comp. Workman's Comp pays those. Now that election has been made, and you can't sue your employer.
Well, you know what? There's a lot of people that get hurt all the time. What would you say would be some of the most interesting, because those are fun. We all like to hear some of the most interesting cases that you've dealt with.
We dealt with a case a number of years ago where the workman's comp benefits were waived, and an individual actually, and it was a very sad case, he was working in a trench. It was improperly supported, it was shored up, as it should have been under OSHA requirements, and there was a cave-in, and he unfortunately passed away. Those are very, very sad things that happen, but those types of things can happen on the job, and employers can be held liable under those circumstances where they knew or should have known that it was a very dangerous situation. They could have been grossly negligent at that point, and the cave-in occurs, and then, of course, the injuries happen. What people also need to know is sometimes they may be on the job and they may be injured, but there could be a third party other than their employer who's responsible. For example, they climb a ladder. The ladder may have been improperly designed or improperly braced, and the ladder fails and they fall to the ground, they're injured. Well, the manufacturer of the ladder could be responsible. If they're in an automobile and they're driving while they're working and they're involved in an accident, certainly the person who is at fault in the accident would be responsible for the injuries in that case also. So in many cases, a third party could be liable. And it's important then to get a consultation to find out if there's a possibility that someone else may be liable for your damages other than your employer.
Absolutely. Now, you work with people statewide.
I do. And we'll travel anywhere in the state to see them and to talk to them, and it'll be a no-charge consultation.
Yeah, there's a free consultation, and there's a lot of different reasons why. It's your right. It's your right to be able to be compensated for something that might have happened to you. What would your final words be for them today?
Knowledge is power, and they need to understand that when they have a free consultation available and they can get information from an attorney to find out what their rights are, then they're not going to be sold short. They're not going to be in a situation years later where they say, I wish I would have, could have.
Spell your last name for him so I don't do it wrong.
I will do that. It's Koglmeier.
Law.com. Now, the phone number to call them, they do free consultations and they're statewide, and they will come to you anywhere you are. It's on a contingency basis. That phone number to call, it is area code 480-962-5353, and find out what your rights are by giving them a call.